Hi, I'm David Chapman, and I'm going to be talking to you about land use controls today. Thank you for joining me. And this is a particular subject that I'm passionate about because I spent 4 years of my life on a city council for a city in Oklahoma called Edmond. And I was the Ward 1 City Council. So I spent a lot of time in planning commission meetings and then a lot of time in city council meetings making decisions on land use. And so land use controls is something that's very important. It's very important in our history. So the first thing I want to do is just say a bit about the history of land use controls. In the early United States times, most of the land was owned by the government. And so we had to transition that land to individuals. That movement moved west, and it caused small towns to grow as we gave land, or we sold land, or we entrusted land to individuals. Moved to the east, and in the east, the focus of land controls was a very orderly development of streets and infrastructure. And so it was a necessary component to build the United States out is to use that land for infrastructure. And that's how we based a lot of our land use control today, on what was needed in the past to build out the United States as a new country, the things that we needed. So it became apparent that the layout of the streets and the location of utility systems could be more efficient and accomplished by imposing land use controls as this growth took place going forward. And so that's what we tried to do, and that's what transpired later, was try to put some efficiency into the what we call zoning that describes the uses that are acceptable and controls land use. So going forward, we call that zoning, and typically municipal zoning laws are under the control of a regulatory body, usually a zoning commission, a planning commission, or a city council in a municipality, a city. So that's typically how they're organized. And generally the basic designations are residential, commercial, industrial, and agricultural. So we'll see those four designations in general pretty much throughout the United States. Zoning laws can be changed, they can be updated, and will over time by city councils, planning commissions, with consideration from citizens in the area. One of the ways that we can do that, other than change the zoning, is we can take variances. So if a use is requested by the city planning commission, the person would be asked to file for a variance, and then that variance would be taken to the planning commission and then be taken to the city council to change to use some other use other than what the zoning permits. And that's called a variance. And frankly, that's one of the reasons that we have city councils, is to make decisions on things like variances. So anytime that you make a variance for something and you're making an allowance for somebody to do some use, there's going to be controversy that goes along with that. And so I spent 4 years of my life dealing with that controversy in granting or not granting variances for specific uses that are different than the land was zoned or planned for in the first place. So we call those variances. I've been writing a lot lately and speaking a lot lately on some alternative to variances, and I'd like for you to take a look at those articles that I've written. You can get those at jdavidchapman.com, jdavidchapman.com. Those are going to be PUDs, which we call planned unit development. That is a way that we can put multiple variances into an agreement and negotiate that with the planning commission and the city council for a development. It's called a planned use development, and I'd like for you to take a look at that. The second thing is overlay districts. Overlay districts are, the purpose of an overlay district is for us to consider uses that aren't normally considered in the rest of the city. So I think you could agree that there would be some areas of town that would be more fit for some use than others. But when we did the zoning, we put the same requirements, the same restrictions on the entire town. But there may be parts of town that we want to put a further restriction on, maybe no development there. Or we may be more liberal with the development, maybe higher density or something like that. So an overlay district allows us to put a whole section of the town into sort of a package that allows certain variances by what we call by right. That means you have the right to do it without going to Planning Commission and City Council. Now, when we do overlays or when we propose overlays, there is a natural resistance from the community against those in a lot of ways, and they're typically what we see from their complaints is that it takes the voice away from the citizen at City Council to argue it because it's given by right now, because it doesn't go in front of Planning Commission, it doesn't go in front of City Council. So there isn't any feedback mechanism for people to go to fight against it. So we see that. And then secondly, they just don't like whatever the thing allows in the community. So we see those things, and again, this is part of the source of controversy. PUD is the same way. When we do a PUD, there are citizens that do not like the things that the city has negotiated with the developer in the way of variances for that development. So these are things that we see in the zoning that is frustrating to city staff, frustrating to Planning Commission, frustrating to City Council, and frustrating to the citizens. So this is a tough one to get through. But those are the things that are necessary. Also, to enforce zoning and building codes and things like that, we have what we call police power, which is one of the 4 powers that's granted to the government, and it's called police power, and that gives them the right to go and to actually enforce the zoning or enforce building codes. And so we'll talk about that later as well. So that's a bit of an overview and a history of zoning. Let's talk a minute about codes. Codes are intended to protect the public against low quality or dangerous construction or issues that might come from that. Provide a minimum standard for structural loads, balconies, buildings, ventilation, structural insulation, plumbing, electrical, fire protection, and those things. We call those building codes, and it's just an effort to protect the public for construction that's taking place in the city. They don't end construction when construction's complete either. We have going forward, we have codes that say that you must keep your yard at a certain level so that it's not a nuisance. We have parking codes that require a certain number of spots for businesses or lack of. We may even restrict parking in areas. So these methods of enforcement vary with the community, with the municipality, and so it's up to, in general, it's up to the municipality to figure out what it is they need as far as building codes to keep the public safe. Okay? So the next thing we're going to talk about are subdivision requirements. Subdivision requirements generally came about with the invention of the FHA, the Federal Home Loan Programs would require certain requirements in neighborhoods before they would loan on the homes. And so this is sort of where we saw this. And one of the big items was flood control. So flood control districts have been created and given authority to set up minimum requirements in land development so that they ensure that flooding won't take place, or if it does, that we understand the risk associated with hot rising waters in those areas. So the FHA and the VA set minimum standards for subdivisions. They have subdivision requirements for curbing, for sewer, storm sewer on the roads, for asphalt or concrete. So there's a lot of things like that that the FHA and the VA require that just ensure quality in the homes that they give loans on. So those are some sort of neighborhood things. I will also say this. One of the things that we see that people don't understand is if you buy a home with a gated community, then the municipality or the county will not likely have responsibility for those roads. So if you buy a home in a gated community, you need to understand that the community that you're buying into will have the responsibility to keep their roads in order, to fix the potholes and things like that in that neighborhood. And the city and the county is not going to be responsible for those roads. Now, even with roads without a gate, they have to be up to a certain standard. And if they do meet that certain standard, then the government, the city, and the county will take the responsibility for those roads in general. So those are something you just want to think about whenever you buy a home. Personally, you might want to look into who actually takes care of those roads, because it's an expense that is significant, and it is often put on the homeowners association, in which they have to give assessments for. And you need to understand that whenever you buy a house, if you're going to be responsible for paying an assessment to fix those roads. So consider that whenever you look at a gated place. So next thing I want to talk about is planning. This is a really good career path. Planners are generally, they work for architecture firms, engineering firms, and city, municipalities, and county governments. So the planning function looks forward and says, what's the population increase? Where's the population increase going to take place? What amenities will that population need? Where do we need housing? Affordable housing is under planning. Transportation is under planning. All of those things come into play whenever we start talking about planners. Really a good career path for those that like to look forward and consider what's needed in the future. So the implementation of zoning laws require a certain amount of community planning, because we go out and we have to hold meetings with the city to find out what it is they want, whatever they're going to require, and put as early as we can, put an emphasis on the status quo to give encouragement to the concept of urban or regional planning, working with other entities, other cities on connecting transportation. All those kinds of things come into play when we talk about a planning program. There are two ways to restrict uses when we talk about land use. One of the ways is to restrict by private agreement. We have deed restrictions, so you can put right in the deed the way that things can be used. So we could put in the deed what types of business can be conducted in that building or on that land. We can restrict the use of alcohol. We can put restrictions that something has to be made of brick or can't be made of brick. It has to have a fence, a certain kind of fence. We can actually put those things in a deed and make it restricted when we sell it to somebody. Now, there are limitations on private agreements that can take place, and we need to be careful that we, in the ways that we use these private agreement restrictions. And the reason is you have a sort of a failure to enforce. They're difficult to enforce at times. You need to make sure that you have the agreements with the parties and make sure that they understand the restrictions that are put in there. New zoning requirements could actually have an effect on your deed and on the uses. Condemnation and other things and legislative action that could take place might have an effect. So we need to be careful when we use those deed restrictions. But remember, deed restriction is a way that we could limit somebody's use in something. That's more of a private use instead of what we've been talking about would be a public use. So those are the two ways to limit uses of property, either privately or publicly. One of the things I want to talk about in this segment is eminent domain. Eminent domain is a highly controversial subject in the United States. We obviously have a Constitution, and the Constitution has rights, but we need to understand that eminent domain was one of those four things that was given to the government as far as power whenever we started transitioning the rights to citizens of land ownership from the government. Eminent domain was one of them. We already talked about police power as being one of them, but eminent domain was one. And that is the public authority negotiates with property owners to determine an acceptable price for the property. There has to be a couple things that have to take place before eminent domain can be used. The first thing is there has to be fair compensation, like I just said. Fair compensation may have to be required by the court of law, or it's negotiated, whatever's fair. And then secondly, it has to be used for a public use. Now this is where it gets really controversial. Who determines public use, and what is public use? Well, I think that it is, there's an argument, and that argument typically happens in court, to different things being public or not. Is it public for a government to take a piece of land by eminent domain and give it or sell it to a private company who will then hire local people who will then pay income tax and sales tax on the products that they build? That's where the controversy comes in. Some people would consider that a public use. A lot of people would consider that a private use and not capable of being purchased or taken by eminent domain. So two things have to happen. It has to be fair compensation. It has to be for public use. Again, both of those might be decided in court, and many times are decided in court. I've written about those as well, and you can see more about eminent domain at jdavidchapman.com. There is a famous Kello versus City of New London is probably the most famous case that we get case law from in eminent domain. There's this other idea of something called taking. In 1987, the United States Supreme Court ruled that land use officials can be held liable for damages if zoning regulations prevent landowners from using their property. The government preventing you from using your property is called taking. And this 1987 ruling by the Supreme Court is what we fall back on when we look at uses that the government restricts of private landowners. And so that's also something to consider, what is taking and what's allowed. And we have to go to court many times to determine what the government can prevent us from doing on our land. Other government influences that we talk about on land use are restrictions on sewer and water lines. We're doing a development at a lake in Oklahoma right now, and we are being forced to hook to a water line, to a public sewer line. So what they say is this. They say if you're going to hook to public water, which you have to, then you have to hook to public sewer. Well, this neighborhood, nothing's been built in a very long time in this neighborhood. There is sewer available, but it's 500 to 600 feet from the property. So we will have to run a 2-inch sewer line underground, pretty deep underground, bore 2 roads to get to this main sewer to hook in. So that's going to cost $30,000 or $40,000 probably in the end. We'll have to have a pump to pump the effluent to the sewer line, and that's going to be expensive. It's $10,000, $12,000 for the pump. So it's an expensive proposition to do this, and we're the only one in that entire neighborhood that has had to do so. Again, we talked about this earlier. Changes that take place in regulation affect land ownership. It also affects land value. This land's not worth as much because of the efforts that we had to put in order to install this sewer line. But it is what it is. I mean, that is the restriction. That is in their rights to require us to do that. And frankly, being that close to the lake, it's probably a good idea that we don't use aerobic or some other kind of lateral lines to take care of that sewer. It's probably better that we go to the public line. And so it's not a choice anyway. We're going to have to do it. But in the end, we think that it's going to be an investment that's worth doing so we do it. So the same thing does the land that determines land use is is that capability even there? If it's not there, what would we do? What would be the value of this land if there was no public sewer? What if there's no water? With water, you can generally use water wells if it's allowed. And then electricity and natural gas products. Are there electricity and natural gas to the property? You've got to have something to power the home or the business, and so you've got to have those things, and that will determine the land use. We're also seeing with the green sort of revolution that's taking place and global warming efforts and things like that are affecting the land use and influencing land use and the way that we use land. In this area, we also talk about environmental impact statements. National Environmental Policy Act of 1969 required the preparation of what we call an EIS, Environmental Impact Statement, for any major federal project that will affect the environment. So we got to do these environmental impact statements based on our research, and copies are commonly submitted to the school districts, the water department, the sewage control district, the flood control district, the highway department, and just things that might be able to restrict your use by the impact that you recognize in your statement. So those are all things that should be considered when we talk about land use. And I appreciate you being with me.